Namaskar, viewers. I welcome you to the podcast pertaining to important judgments during the first half of May 2025. I'm a little bit sorry. I'm sorry for the little delay which has occurred in presenting this video because I was mostly out of station. I'd been traveling. But however, having said that, I'm sure you're going to like the judgments because each of the judgments give you something, offers something new to you. So with this, I take you over to the podcast. We are on the screen of Section 141 of Insolvency Bankruptcy Code on Guide to IBC website. Section 141 deals with restrictions on bankrupt. You know that when a bankruptcy proceeding starts, there are a lot of restrictions imposed on the bankrupt. One of them is the bankrupt is not allowed to travel overseas without the permission of the adjudicating authority. Now, the topic says that we are interested in topic 3, which says the request to travel abroad must be based on genuine need to travel. Now, traveling abroad is a fundamental right, but in the case of bankruptcy, that is stopped, but then court allows if there is a genuine need. Okay, so the request to travel abroad must be based on genuine need to travel. Our interest is case of Sunil Sundar Bhai Kakkar versus Samir Ganesh Bhai Marathe and others. Company Appeal Suens of 2026. In this, what happened? There was a ERP contract for which the bankrupt wanted to travel to UAE, and he placed a purchase order also for the attention of the adjudicating authority, but the adjudicating authority denied. So the matter went to NCLAT. NCLAT looked deeply into the purchase order and came up with a judgment, which is our interest. I would strongly recommend viewers to go through the judgment because this is going to give you a good insight about the matter. Now, with this, let me take you over to the slide which I have prepared for you. Now, let us see what are the headlines. What are the main headlines of the judgment? The prayer in the application of the appellant in the application was only permission to travel till March 2026. Admittedly, the said period has come to an end. So this is a recent case. So the petitioner had wanted to travel till March 26. The period has come to an end. There cannot be any dispute to the proposition that in the appeal, which is continuation of the proceeding initiated by the party before the adjudicating authority, court can always consider the relief on the basis of subsequent events. The issue which has been raised between parties is regarding true interpretation of purchase order dated 10/2/2025, relied by the applicant. The implementation of all required IT system of ERP was period 11/2/2025 to 10/3/2026. And the second item, parallel run for 6 months was provided. So the ERP system, which was supposed to be installed by the party, was between 11/2/2025 and 10/3/2026, and the second term was parallel run for 6 months was also provided. For both the work, rate was also mentioned. In item 1, the total amount was 39,000 AED, and for item 2, the total amount was 12,000 AED, totaling 51,000 AED. A look into the purchase order cumulatively leads one to the conclusion is that the work awarded to the appellant were to run simultaneously. That is implementation and parallel run. And installation, implementation and parallel run were to run simultaneously. Thus, the period of 6 months should commence after the expiry of the period of 13 months, that is after 10/3/2026, which is obvious. 6 months would end on after 10/3/2026. In paragraph 10 of the application himself has mentioned the duration of the period of was 13 months. Even if the any further travel can be considered in the appeal as prayed, the period of work order having elapsed, the very basis for praying for travel to abroad cannot be considered. Because the order was you implement the implement the ERP by 11 to 2025 and 10 2026, and then the parallel run. Now, March has already gone. So the work order needs to change until and unless the work order changes and the new terms come out. There is no need for travel. The work order is elapsed. So the court said that even if the prayer for further travel can be considered, period of work order having elapsed, the very basis of praying for travel abroad cannot be considered. It shall be open for the appellant to make fresh application before adjudicating authority in event there is any such circumstances or occasion arise for travel abroad. Because this is a fundamental right. He can again come back and seek permission, but it has to be based on confirmed logic, confirmed requirement. So with this, we move on to the next. Please. Here are the dashboard of topics pertaining to Section 5, Subsection 8 of Insolvency Bankruptcy Code on Guide to IBC website. Section 5, Subsection 8 deals with financial debt. Our topic of interest is topic number 18, which says that for any debt to be treated as a financial debt, the prerequisite is disbursal of money to the borrower. Prerequisite is disbursal of money to the borrower for utilization by the borrower, and that the disbursal must be against consideration of time value of money. Let me read it out again. For any debt to be treated as a financial debt, the prerequisite is disbursal of the money to the borrower for utilization by the borrower, and that the disbursal must be against consideration for time value of money. The cases of Amisha in Sky Creation Private Limited versus Sandeep T. Maheshwari RP and another company appeal so of 2025 NCLAT judgment. This is a very interesting case. This is a very interesting case in the sense what happened was this was an appeal in which a claim was filed by a guarantor who had mortgaged its property for the debt to be availed by the corporate debtor from a bank. And there was an agreement by which it was charging interest at the rate of 1.5%. Now, when the company went into insolvency, the borrower, the person who had mortgaged its property, lodged its claim as a financial creditor. Now NCLT had to consider, and NCLT considered and opined that he is a secured financial creditor against which the matter went to NCLT. And NCLT, this is quite a detailed judgment and very interesting judgment at that. And as always, I'll recommend my viewers to go through it. But to make it short and precise and understandable, to make things easy, let me take you over to the slide which I prepared for you. Now, what NCLAT said was the definition of financial debt under 5 subsection 8 of IBC emphasized that essential elements of financial debt is disbursement against time value of money. We all know that. For any debt to be treated as a financial debt, the prerequisite is disbursal of money to the borrower for utilization by the borrower, and that the disbursal must be for the consideration of the value. Consideration for time value of money. Means what? Brigade will be placed. 3 segments. There has to be, in order to be a financial debt, prerequisite of 3. There has to be first disbursal of money from the creditor to the borrower. Then the borrower has to utilize the money.
And then the consideration for the said disbursal should be for the time value. Time value of money, as opined by Honorable Supreme Court, may be interest, may not be interest also, may be interest free also. In terms of deed of agreement, Amisha is entitled to receive interest from corporate debtor at the rate of 1.5% per month on the amount of money borrowed by corporate debtor from State Bank of India. The post-dated checks of interest payment were at best only a promise to pay a specific sum of money at any future date without creating any mortgage charge hypothecation on any property owned by the corporate debtor. It was merely a check, post-dated checks. So it does not create any hypothecation, nor any charge, nor any kind of security interest. The guarantee agreement clearly denotes that the parties to the guarantee agreement are Amisha and SBI without any mention of the corporate debtor. The guarantee agreement was also not tripartite. It was between two parties, State Bank and Amisha. So when neither of the party, when neither any payment or disbursal was made by corporate debtor or by Anisha, nor was the purported guarantee given by Amisha to the corporate debtor, the Amisha cannot be seen to rightfully claim to be a secured financial creditor for the CB. When there was no disbursement of money and no guarantee given, nothing is there, then in such case, how can you be treated as a financial creditor? There may be time value, but the disbursal of money is not there. The mortgagor property cannot assume the character of disbursal of financial debt in terms of 5.8 or 5. The impugned order suffers from grave infirmity in holding Amisha to be a secured financial creditor. The claim of Amisha may be allowed by RP after categorizing their status as other creditor. The RP, however, rejected their claim for the second time on 18/5/2023, which reasons are not available on record, but ostensibly not on the grounds of delay. So, Honorable NCLT held that they cannot be taken as a secured financial creditor, but they can be considered categorized as other creditors. Because question of secured creditor doesn't arise. Question of financial creditor does not arise. So they can be treated as other creditors. So this is a lovely topic. So let us move to the next topic. We are on the dashboard of Section 7 of Insolvency Bankruptcy Code on to IBC website. The topic 54 says that IBC is not a forum for recovery of debt. Viewers, since you have been, I consider that everybody knows that IBC cannot be used as a recovery forum. And topic 54 says that IBC is not a forum for recovery of debt, which means all the same. Our topic of interest, our case of interest is Dhanalakshmi Bank Limited versus Mohammed Javed Sultan and others, Civil Appeals so 2022 Supreme Court. This is a very recent judgment and a fantastic judgment, I would rather say. It has gone to the core of Insolvency Bankruptcy Code. The case deals with, there was one landowner. I mean, he bought a plot of land and he approached Shrachi. Shrachi is a company to develop the plot of land. He approached also the bank to provide loan. The loan was directly to be sent, loan proceeds was directly to be given to the developer. The developer was to develop the land. There was a four-party agreement. Even West Bengal Housing Infrastructure Development Corporation, that is WBHIDCL, also was a party to the agreement of memorandum of understanding between all the four parties. Well, as the situation stands, the landowner went into insolvency. Actually, did not go into insolvency. Bank took it to, the company became NPA. Bank initiated proceedings under Recovery of Debts Insolvency Act and RDBFI Act, And then the matter went to, and along with that, they moved a petition for winding up of the city. By order of Honorable High Court, the matter was transferred to NCLT, and NCLT admitted the financial creditor under Section 7 of Insolvency Bankruptcy Code. The matter was challenged at NCLAT, and NCLAT also upheld the judgment of Honorable NCLT, and then thereafter it went to Supreme Court. Now, Supreme Court, this is a fantastic judgment. It's a small judgment running for about 10 pages. But I would say it goes to the core of insolvency bankruptcy process. And this is for the possibly, that how insolvency bankruptcy code should be looked into. This is an eye-opener of a judgment. So with this, I would strongly recommending that my viewers to go through the excerpts of the judgment as featuring on the website. Let me take you over to the slide which I prepared for you. The Honorable Supreme Court held that the scheme of the code is to ensure that when a debt becomes due and is not paid, insolvency resolution process begins. The code operates as a collective insolvency resolution mechanism and not as a forum for adjudication of individual contractual claims. It's a very important line. Code operates as a collective insolvency resolution mechanism and not as a forum for adjudication of individual contractual claims. CD had instructed the bank to disburse the loan amount directly to the builder, subject to terms and conditions of the facility agreement. The quadripartite agreement indicates that the builder had a significant obligation concerning the construction, delivery, and transfer of subject property. The structure of transaction reveals that bank's disbursement was intrinsically linked to performance of the builder's obligation, not by landowner's obligation, the builder's obligation. In such circumstances, the transaction cannot be viewed in isolation as a simple financial lending arrangement between the bank and the CD. This is a fantastic line. This is the catch line. In such circumstances, the transaction cannot be viewed in isolation as a simple financial lending arrangement between bank and the CD. The present case does not involve a straightforward financial debt default scenario warranting initiation of CIRP. The facts disclose a dispute which is predominantly contractual in nature and is subject matter of the proceedings before DRT, the appropriate forum for recovery. Therefore, permitting invocation of the code in cases such as the present one would amount to converting insolvency proceedings into coercive mechanism for recovery, which is impermissible. You cannot possibly convert insolvency bankruptcy code as a coercive mechanism for recovery of debts. This is not permissible. The order of NCLAT is upheld. Actually, NCLAT negated the judgment of NCLT. They said that this is not possible. And the Honorable Supreme Court upheld the judgment of Honorable NCLT. With this, we move on to the next slide. On the screen, or rather the dashboard of topics pertaining to Section 12A of Insolvency Bankruptcy Code, which deals with withdrawal of application admitted under Section 7, 9, or 10. Now, why I'm in topic 26, which we had dealt maybe long back, it was mentioned that withdrawal under Section 12A may be possible even during liquidation. And this was held in 3 cases of NCLT in 2018, 2025, and even 2024. Now, very recently, it has been held that topic 27 says that Section 12A of the code applies only to CIR proceedings and not in liquidation proceedings. So the message is loud and clear. that withdrawal of application under 12A is no more possible under liquidation. Section 12A of the code applies only during CIR proceedings and not in liquidation proceedings. It was held in the case of Gokul Agarwal versus Bank of India and others, company appeal so and so 24. And this is a very recent judgment of, last week or so. This is a long story. It went back and forth, even went to Supreme Court, the matter, and ultimately NCLAT looked into the judgment. The company had already slipped into liquidation, and they analyzed the matter. They referred to other judgments also, and many past judgments, and then came to a certain conclusion that CIR proceeding during CIRP, 12A can be moved, but not during liquidation. So in order to make things shorter and understandable, while requesting you to go through excerpts of the judgment, I would request you to please go through the judgment, but let me take you over to the slide which I prepared for you. Now, what do we see here? The appellant here is not even the actual applicant in IS so and so, but merely a party in the main CP of 2018. The adjudicating authority, while considering IF so and so, concluded that the application did not disclose grounds which would justify direction sought and consequently dismiss the application. The applicant himself is not present while IA 41 of 2024 was adjudicated. As per Rule 48 of NCLT rules, in case of non-appearance of the applicant, the tribunal may, in its discretion, either dismiss the application for default or hear and decide it on its merit. The adjudicating authority has not violated any law in any other provisions of the law and by its appeal, and the appellant is rather delaying the process of CIRP. The Supreme Court appeal number so and so of 21 is different and does not pertain to this particular matter, which is in front of this appellate tribunal. The final order as passed by Honorable Supreme Court states that civil appeal number so and so of 2024, however, stands dismissed on 26/2/2026. That means the path is now clear. Honorable Supreme Court has not barred holding simultaneous CIRP proceeding against both principal debtor and the corporate guarantor, and such proceedings are maintainable under existing provisions of the law. And therefore, substratum on which the appeal is being adjourned is no longer exists. Section 12A of the code applies only during CIR proceeding and not in liquidation proceedings. The only available mechanism for settlement post-liquidation is the scheme under Section 230 of Companies Act 2013, as contemplated by Regulation 2B of liquidation regulations. Hence, the order of liquidation calls for no interference, and if promoters propose to settle, they may only do so through the statutory Section 232 of Companies Act 2013. So this is a new concept. It is no more the old concept of liquid 12A may be possible during liquidation is possible. It's relevant anymore. This is the latest stand of the court. And this is why this judgment is exceptional. And that is the reason why I shared it with you. Let me move on to the next topic.
Viewers, we are in the middle of our presentation from guide to IBC.com pertaining to May judgments, May 1st of judgments. I hope you are liking the judgments which have come up to you up till now, and more are going to follow.
We are on the dashboard of topics pertaining to Section 19 of Insolvency Bankruptcy Code on Guide to IBC website. Section 19 deals with what? Personnel to extend cooperation to interim resolution professional or resolution professional. Now, the topic which we are coming to is topic number 11, which says that Section 19 does not state anything about any need to deliver information, but broadly state A, who are required to assist or cooperate with the RP, and B, the purpose for which such assistance or cooperation may be insisted by IRP or RP. This is a fantastic topic, I must say. It relates to a very recent case of Sri Sanjeev Kumar Arora versus Deepak Thakural and others, Company Appeals and so of 2022. This is a very recent judgment. In this, what happened? This is a short judgment. In this, what happened? It was moved by the statutory auditor of the company at NCLAT against an order of NCLAT. And this pertained to certain directions of adjudicating authority, asking the statutory auditor to cooperate, and he went to NCLAT. NCLAT analyzed Section 19, and this, in my opinion, is a landmark judgment. It clears so many doubts and so many doubts about Section 19. So I would strongly by recommending that you go through the judgment on the website. Let me take you over to the slide which I prepared for you. Honorable NCLAT said that a resolution plan of a certain resolution applicant had been approved by COC, which might have been rejected by adjudicating authority, and the liquidation was ordered. So far as COC RP combination goes, they apparently had done what was required to be done for a successful insolvency resolution process, and their responsibility stops, which is correct. They had done everything for a successful insolvency process, CIRP process. The resolution plan was not accepted by adjudicating authority. Neither RP is responsible for the same, nor the COC is responsible for the same. So the responsibility for both stops there. Section 19 mandates the corporate debtor, its promoters, other persons associated with the management of the CD to extend all assistance and cooperation to the IRP or RP as may be required by him in managing the affairs of the corporate debtor. Section 19 does not state anything about the need to deliver information. This is very important. Section 19 does not state anything about the need to deliver information, but broadly state A, who are required to assist or cooperate with the RP, and B, the purpose for which assistance or cooperation may be insisted by RP or IRP or RP. The assistance which the RP may insist within the meaning of Section 19(1) can relate only to such information which may be considered necessary by the RP for running the CD as a going concern for the protection of its properties. What does Section 18, what does Section 20 say? That RP is to manage the company as a going concern. Section 23 also says that. So it does not, none of them talk about information. They say that the RP is required to protect the interest of the corporate debtor. That is Section 18, Section 22, Section 25, I'm sorry. So RP is responsible for protection of the property and to run it as a going concern. So information part is not mentioned in Section 19 of the code. Unless a person is associated with the management of the CD prior to the admission of the CD to CIRP, it might be difficult to hold that such a person would be under obligation to assist RP under Section 19 of IBC. Because the definition says what? The directors or persons associated. Now, if a person was not associated on the date of commencement of CIRP, how can you hold the person to be obligated to provide information or cooperate with the IRP or RP? Most critically, such information as sought might be in the custody of such person from whom it is sought, or it should have at least been shown that the person concerned had access to those information. A statutory auditor is a professional who, by the very nature of the audit to be undertaken, cannot be associated with the company whose affairs he is to audit. He is a professional. He is not a servant of the company. Unless it is established beyond doubt that the appellant it will be futile to issue direction to the appellant to part with documents or information that he may not possess. The order passed by a learned adjudicating authority cannot be sustained for A. It has not taken note of the role of statutory auditor and his role in the management of CD. So this is a beautiful order pertaining to Section 19, and it opens our eyes to a lot of misconception. At least I had. I'm not talking of other RPs, IRPs, insolvency professionals, maybe more enlightened than me. But I think this is an eye-opener, at least for me. And that is the reason why I'm sharing this with you. So with this, let us move on to the next topic. We are on the dashboard of Section 31 of IBC, that is Insolvency Bankruptcy Code, on Guide to IBC website. Our topic of interest is topic number 80, which says that concerted efforts and decisive actions are imperative to break the deadlock and ensure the expeditious implementation of the resolution plan. It is not just the responsibility of the SRA. It needs concerted efforts by everyone. Now, our case of interest is Alpha Corporation Development Private Limited versus Greater Noida Industrial Development Authority, that is GNIDA and others. This is civil appeal number so and so Supreme Court. This is a very, very recent judgment. In this, to be brief, what happened was GNIDA, that is Greater Noida Development Authority, had granted to a consortium of parties a big plot of land in Noida for development. Now, in the consortium, EIL was the majority stakeholder, having 81%, 78% initially, which later increased. They were the lead member. And it was required that they form an SPV or SPC, Special Purpose Company, to undertake the development in whose favor the lease was granted. Now, besides this also, another plot of land was leased. This lease was for 90 years. And to another company also, that is NIT Development. NIT Development, a plot of land was given by GNIDA for 90 years for IT park development. Herein, this particular company became the subsidiary of EIL. Then EIL took over other plots also. One of them was absolutely freehold. Now, as the situation would come to, EIL went into insolvency. And GNIDA went into multiple hurdles. The matter went to NCLT, then NCLAT, and GNIDA. I mean, there was a lot of misunderstanding and confusion in between. And ultimately, the matter went to Supreme Court. Here, Supreme Court took GNIDA to task and said that all the confusions which have arisen is because of the inaction and ignorance on the part of GNIDA. They gave GNIDA left, right, and center. So this is a long judgment. It's a 55-page long judgment. You can go through the excerpts of the judgment, which is featuring on the website. It's shorter, much shorter. But it will give you an idea about the judgment, and it will be an interesting read. With this, let me take you over to the slide which I prepared for you. Now, what are the highlights? GNIDA, having executed lease deeds for development of the lands, it failed to keep track and monitor development being undertaken on such lands to ensure timely completion thereof within the stipulated period of 7 years. While it was the duty of CD and SRA and whatever you say, but the land belonged to GNIDA, and GNIDA is a public entity. So it was their responsibility also to make sure that the development takes place within the period of 7 years which was stipulated. The long prior to CIRP of EIL, GNIDA was informed by the aggrieved home and office space buyers of the tardy progress in the construction of the projects, but failed to take necessary coercive steps against the lessees and or the developer, that is EIL. Despite being informed by the IRP in December 2018 and by the RP in March 2019, GNIDA did not even choose to be vigilant after initiation of CIRP proceedings against EIL, which was not expected. GNIDA submitted its hugely belated claim on 11/11/21 in relation to its alleged dues from Neo Multimedia Limited and never raised a claim in relation to dues on Nishta Software Private Limited. GNIDA addressed its letter to the RP only on 18/9/2019 after approval of the Roma's resolution plan by the COC on 26/8/2019. Now, what happened was GNIDA raised a claim of 141 crores. On 18/9/2019, whereas the resolution plan got approved on 26/8/2019. GNIDA did not point out at NCLAT that its appeal against NCLT's order of 8/6/2021 was limited only to the projects on its own leased lands and did not extend to Alpha resolution plan in relation to earth copia on freehold land at Gurugram. GNIDA raised a claim before RP in September 29, claiming to be a financial creditor and that its due was 149 crores had to be admitted. Think of it, GNIDA is a financial creditor. It has provided land lease. Given the facts, this was eminently a fit case for lifting the corporate veil, as EIL was the main driving force in the development of the project and in payment of GNIDA dues. You see, corporate veil, piercing of the corporate veil is not an easy thing. So herein the court found that there are so many entities involved and dues to GNIDA had to be cleared. So it was necessary, it is imperative that the court pierces the corporate veil and looks into the matter. The minutes of the monitoring committee meeting held on 10/8/2025 evidence that Alpha undertook that it would absorb dues payable to GNIDA and the same would not be burdened on the allottee or buyers. Roma does not propose to charge GNIDA's dues to the home buyers of Earth Town and is willing to bear the entire burden itself. The inertia on the part of GNIDA and its failure to protect the interest of the home or office space buyers, apart from its own interests, clearly disentitles it from levying penal interest or penal charges or time extension penalties. There has to be a punishment. There has to be a punishment, and this was actually pronounced by NCLAT, which was affirmed by Honorable Supreme Court. Registration of the home or office spaces in favor of the allottees shall be undertaken only after payment of dues of GNIDA in totality and with its active participation so as to confer the status of sublessees upon the buyers. Because the prime interest of the CIRP process is to protect the interest of the buyers. GNIDA would not be entitled to any interest on the principal amount due for the extended period of 24 months, during which the successful resolution applicants, Alpha and Roma, are required to clear dues. They wanted a reasonable time, and which was granted to be 24 months, and GNIDA would not be responsible, would not receive any interest. And that was the penalty imposed by Honorable Supreme Court. So this is an interesting case, that it's not just the SRA. Even the party, the leasing party, even if it's a government organization, can be held responsible. So with this, we move on to the next case. We are on the dashboard of Section 60 of Insolvency Bankruptcy Code. And again, we are dealing with a small case, but a dynamic one, which tells us something new. We have read in Section 7 that it is possible for a group of companies can be admitted together through group insolvency. Even in the Insolvency Bankruptcy Code Amendment Act 2026, a new chapter has been introduced with regard to group insolvency. But herein, what we are our topic, that is topic number 127, says that if more than one corporate debtor themselves pray for consolidation of CIRP, the same may be allowed, and in such case, the process has to restart. And the joint CIRP, the steps as per IBC and regulations have to be taken afresh. So that means a group insolvency is possible even now. So this is a not in section 7. This can apply to anything. So whether it is a section 9 case, whether it is a section 10 case, if there are more corporate debtors and who say that is irrespective of their being admitted under which section, that is also not relevant. The CIP process of more than one corporate debtor, if the corporate debtors insist that they should get consolidated, then the consolidation can be allowed. The cases of Radha Miltech India Private Limited versus Solitaire Info Media Private Limited, Company Appeals so 2026. This is a recent judgment. In this case, what happened was more than one corporate debtor wanted consolidation, but resolution plan pertaining to one company had already been approved, but the court considered the consolidation, and which is important. And the matter, the SRA took the matter to NCLAT, objecting to such. And so let us go to the slide which I prepared for you. This is a small case, but a dynamic case, as I said. So let us go to the slide which I prepared for you. Now, the Honorable NCLAT held that when both CDs themselves have prayed for consolidation of the CIRP, there is no error in the order of adjudicating authority directing for such consolidation for initiation of joint CIRP of both the corporate debtors. That's exactly what I said. Since creditors are same and plan has been approved by COC, the process has to restart. And the joint CIRP, the steps as per IBC and regulations have to take place afresh. When consolidation has been made, both has to be treated to be consolidated into one CIRP process. So the SRA who had submitted the plan, that plan, though approved by COC, does not stand. But he is welcome to submit for a consolidated plan. And both CIRPs will be taken to be one CIRP. So the group insolvency, which is proposed in Insolvency Bankruptcy Code Amendment Act 2026, it is already, the Honorable NCLAT has already provided for that in this particular judgment. And that is why this judgment is exceptional. So with this, we move on to the next slide. Viewers, we are on the dashboard of Section 12A of Insolvency Bankruptcy Code, which is withdrawal of application under 7, 9, or 10. We are seeing it on Guide to IBC website. Our topic of interest is topic number 53, which says that Form FA can only be signed by applicant who has initiated the CIRP proceedings. This has got a Section 33 angle as well. So let us see Section 33. Here we have topic number 44, which says that if there is no one to carry the COC, the adjudicating authority has no option but to order for liquidation. Fine, let us see the case. This is the case of Chittaranjan Ganesh Naik versus Schaffler Elmotech, Statomat GmbH, Company Appeal so NCLAT. In this case, what happened? This is a very small case, but a startling matter. And what we are interested is in exceptional cases. In this case, what happened? There was only one operational creditor in the company. The operational creditor was paid by a financial creditor who was a related party. Now we know that a related party cannot be a member of creditors. So under such circumstances, the 12A could not be admitted because the operational creditor had already been paid off. So who was there to move from 12A? So the adjudicating authority came to the opinion that since there is no one carry forward to take forward the COC, and this is a creditor-driven process, so there is no option but to move for liquidation. The matter went to NCLAT. Now let us stop the screen share here and look at the slide which I prepared for you. It's a small slide. The main highlights are it is clear that only operational creditor was the sole member of COC whose debts have been cleared by the financial creditor. I have already told you this. The financial creditor is a related party of the corporate debtor, but application for withdrawal was not filed by the applicant who initiated the proceedings. The adjudicating authority has rightly taken the decision, there being no one to carry the COC, to direct for liquidation, which is the only option in the fact of the present case. Now you can have a question here, why not dissolution? Well, it is obvious that the company had some assets. And if the company has assets in its balance sheet, dissolution cannot be ordered. So under such circumstances, the adjudicating authority, this is an assumption, but the fact is if there are assets in the company, then the company cannot be dissolved. And in such circumstances, the liquidation has to be ordered. So this is an exceptional case. So let us move on to the next case. Here we are on the dashboard of topics pertaining to Section 61 of Insolvency Bankruptcy Code in Guide to IBC website. Our topic of interest is topic number 58, which says the filing of an appeal without even applying for a certified copy of the order practically means that there is no filing of an appeal in the eyes of law. This was held in the case of Angelwood's Apartment Allottees Association versus M. Lalitha and another civil appeal number so-and-so of 2025 by Honorable Supreme Court. This is a very recent judgment. What happened in this case is that the NCLT Kochi bench had approved a resolution plan, and mother of one of the suspended board of directors had moved an appeal. The name of the company was Samson and Sons Builders Developers Private Limited. The appeal was filed with 15 days delay, which was a request was made for condonation of delay. But there were defects. The defects, after curing it took almost about 150 days to cure the defects. But yet, the certified copy of the order was not attached thereto. NCLAT allowed the order, allowed the appeal, permitted to consider the matter and passed a judgment also. This matter went to Supreme Court, and Supreme Court analyzed the thing in detail. I would recommend my viewers to please go through the excerpts of the judgment on the website because it will impart a lot of knowledge to you. So with this, let me take you over to the slide which I prepared. The Honorable Supreme Court said that in effect, even after refiling of the appeal on 10/3/2025, one of the glaring defects that still remained was that the certified copy of the order of 14/8/2024 sought to be impugned in the appeal was not filed. In the case on hand, the appeal which was refiled by respondent number 1 was defective beyond redemption because the order which you're challenging, the certified copy of the order was not there. So it was a defect which was beyond redemption. The act of filing of an appeal for a certified copy is not just a technical requirement for computation of limitation, but an indication of diligence of the party in pursuing the litigation in a timely fashion. On 10/3/2025, when it was refiled, the appeal was not accompanied by a certified copy of the order dated 14/8/2024. Respondent number 1 chose to e-file an appeal against the order of 14/8/2024 on the very last day available to her in terms of the limitation prescribed under the provisions of Section 61, subsection 2 of the Code. The filing of such appeal without even applying for a certified copy of the order dated 14/8/2024 practically meant that there was no filing of an appeal in the eyes of law. Supreme Court further held that Respondent 1 did not even apply for a certified copy of NCLT's order dated 14/8/2024 till 21/4/2025. That is almost more than 6 months later, long after the refiling of the appeal on 10/3/2005. Respondent 1 does not even choose to file an application for an exemption from filing a certified copy at any point, be it at the time of filing of the appeal on 28/9/2024 or its refiling on 10/3/2025. They could have applied for an exemption, which they did not. The NCLAT totally lost sight of these vital aspects while considering the two applications filed by Respondent 1, seeking condonation of delay in the filing and refiling of the appeal. Filing or refiling of the appeal by Respondent 1 was incurably tainted, and the same ought to have been rejected at the threshold. In view of the above, Supreme Court held that the order dated 10/11/2025, passed by National Company Law Appellate Tribunal, Chennai, in IA number 1164 and 65 of Company Appeal number so and so of 2025, is accordingly set aside. So this we have had earlier also, number of cases pertaining to certified. What is a certified copy of an order? Now this adds another dimension to it, and that is why this is exceptional and important. So with this, we move on to the next case. The dashboard of Section 94 of Insolvency Bankruptcy Code on Guide to IBC website. 94 deals with application by debtor to initiate insolvency resolution process pertaining to a corporate guarantor, of course, now. Our topic of interest is topic number 11, which says that for Section 94 application, the limitation starts running against the personal guarantor for taking proceeding under 94 from the cause of action which arose. This has a Section 238A aspect also. So let us look at Section 238A. In 238A, in topic 58, it says that extension of limitation under Section 18 of Limitation Act is when other side acknowledges the debt. There is an acknowledgement. Just the borrower acknowledge, writing a letter will not suffice. Even the creditor has to acknowledge it. Then only Section 18 is applicable. Now let us go to see the case. This is a two-page judgment, but a radical one, and that is why I'm sharing it with Yogesh Kumar Thakkar versus Indian Overseas Bank and others. Company Appeal Suits of 2026. Very recent judgment, a two-page judgment, but really a fantastic one. This being a two-page judgment, it's just the entire judgment is possibly here. So I would request all my viewers to please go through this judgment. While saying so, let me take you over to the slide which I prepared for you. Now, what Honorable NCLT said, for Section 94 application, the limitation starts running against the personal guarantor for taking proceedings under Section 94 from the cause of action which arose. In the present case, cause of action arose on 27/6/2016 when 13-2 notice was issued, and thereafter when recovery certificate was issued on 18/2/2019. So cause of action started because the 13-2 notice mentioned the name of the corporate debtor as well as the personal guarantor. So the cause of action started on 27/6/2016, and thereafter when the recovery certificate was issued by DRT on 18/2/2019, this gave rise to another cause of action. The fact that appellant had sent letter to the bank offering one-time settlement on 28/12/2020, then 16/7/2022, shall not give benefit to the appellant for extending the limitation, giving benefit on Section 18. Why? Extension of limitation under Section 18 of Limitation Act is when the other side acknowledges the debt. That means the bank, even if the one-sided, the borrower was writing letters to the bank, it does not matter. Because 22, look, why it is important. If you take 22, and if the case is filed in 2000, beyond 6th of July 2025, it will be barred by limitation. So here the court said that no, it does not make any difference. And they got the benefit of suo motu order also of COVID-19. So automatically it was had to be within time. So the application admittedly having been filed by applicant in 2025, which is clearly beyond the time, and the adjudicating authority has rightly rejected the application to be barred by time. They did not get the benefit. It was filed in 2025, and this arose in 2019 was the order. So even if 2019 was the COVID period started in 2020. So that did not matter. So that it went beyond the time, and so adjudicating authority said that this is barred by limitation. And why? Because extension of limitation under Section 18 of Limitation Act is when other side acknowledges the debt. So other side acknowledged, even if it acknowledged debt, it did not acknowledge. So the debt concern was 18 to 2019, and automatically this BB not coming under the suo motu period, so it was barred by limitation. So this is a beautiful judgment. So with this, we go to the next slide.
Viewers, we have come to the end of our presentation. I hope you like the judgment. Please do like our presentation. Your likes motivate us, and your comments are really helpful. So we look forward to your comments and your guidance and your likes. With this, I conclude the video and look forward to seeing you towards the end of this month. Thank you. Bye for now.